The death of a spouse ends a marriage, and just as when a marriage ends in dissolution, property must be divided. Recall that during marriage, each spouse owns his or her separate property plus a half interest in all community property. In the event of death, it's necessary to determine which of the decedent's property passes to the surviving spouse and which property passes to third parties. The rules governing such a determination come from the Family Code, the Probate Code, and case law. A lot hinges on whether a decedent spouse executed a valid will prior to death. If so, then his or her property will pass by testate succession, meaning under the will. A will may devise a spouse's separate property and that spouse's half of community property, including quasi-community property, to persons of the spouse's choosing. The will can't devise the other spouse's half interest in community property. That half remains the surviving spouse's property upon the decedent spouse's death. If the will leaves all the decedent spouse's property to the surviving spouse, then the property passes to that spouse without any need for a probate process. Imagine that during marriage, a wife executes a will leaving all her property to her sister. At the time of the wife's death, the spouse's only community property is their house, which was fully paid for using community property wages. The wife's separate property consists of $300,000 that she inherited from her mother during marriage. The money and the wife's half interest in the community property house pass to her sister. The other half interest in the house remains the husband's property. Let's now consider what happens if a spouse dies without having executed a valid will. The spouse's property will pass by intestate succession to the spouse's heirs as prescribed by California's intestacy statute. The intestacy statute strongly favors surviving spouses.